Hello students, I hope you have understood part 1 of vicarious liability, which dealt with the introduction and the concept of master-servant relationship. We now move on to part 2, which majorly discusses specific instances of how master and servant liability is imposed and in which situations is it imposed. We will then move on to the doctrine of common employment and subsequently move on to discuss the principal and agent relationship in terms of vicarious liability. Let us now begin with specific instances to discuss the liability of employer in cases of vicarious liability. Now, at the onset, let me make it clear that these cases are only illustrative and not exhaustive. That is, there can be different situations, and the liability of master servants depends on the facts and circumstances of the cases, and the courts might apply different tests to determine whether a person is a servant or not. Now, let us take up the first example, that is negligence by medical staff. So, you have already understand that medical staff or staff kept by hospital is specialized staff, that is they have special skills and knowledge. So in case of any negligence by them, can the hospital administration or the owner of the hospital be held liable? So the classic example here is Cassidy versus Ministry of Health. In this case, the claimant was a patient at a hospital which was run by the defendants, who required routine treatment to set bones in his wrist. Now, the claimant is the one who required routine treatment for setting his bone in on some place, fixed place. Now, due to the negligence on part of one of the doctors, the operation caused his fingers to become stiff. The defendant was sued by the claimant in tort of negligence on the basis of vicarious liability. So, because of the negligence of the doctor, the hospital was sued. Now, the court held that the defendants were vicariously liable. The fact that the worker engages in specialized and technical work for which he is specially qualified does not necessarily mean he is not a servant. The court held that a person is a servant of the defendant if he chooses the job by the defendant and is fully integrated into the defendant's organization. In this case, the doctor were appointed to the hospital by the defendant and had not been chosen by the patient, and the doctors were fully integrated into the hospital. So here, the doctor was not chosen by the patient himself. Rather, the hospital had selected the doctor, and it was that doctor who was working for the patient. And next, he was integral part of the business, and he was integrated into the business of the hospital. That is, the doctor is integral. So here he was held to be a servant and hence liable in this case. So the defendants were liable for the doctors, hence vicariously held liable. So here the test of integration has been applied and held that because they were integral to the part, and second, because the patient did not choose the doctor, rather the hospital has chosen the doctor, and hence the hospital will be vicariously liable for the negligence of the doctor. Now, the next situation is, what happens if I lend my servant to somebody else for services? Will I be responsible for any negligence done by the servant, or will the person to whom my servant has been lent be responsible? So, the case is Mercy Docks and Harbour Board versus Coggins and Griff Limited. In this case, Mercy Docks is in charge of training and providing crane operation to service companies who are in the carrier businesses. Now, on one occasion, Mercy Dock operators lent one of the operators to a stevedore company. Now, because of the negligence of the driver, there was a person who was injured while loading of the ship. So, in this case, the question was, who will be held liable? Whether the persons who have been lent or Mercy Docks. The House of Lords here held that the Harbour Board, that is Mercy Docks, was the general and permanent employer of the driver, and he was liable to the person who was so injured. The stevedores were not liable, even though at the time of negligence the driver was loading cargo for the stevedores. The reason was that, although at the time of the incident the stevedores had immediate control over the crane driver insofar as they could direct him to pick up and move the cargo to a particular direction, but that alone could not make them liable. They had no power to direct as to how the work had to be done or how the crane had to be operated. The question of liability depends on many factors. An important consideration: who has the power to direct as to how the work is to be done is one very important factor here, right? So, in this case, it had been held that only the person who has the power to direct what work has to be done is not liable. How the work has to be done also is liable and is important consideration. So, the important consideration here was Steve Dawes did not have the did have the immediate control, but did not have absolute control. It was Mercy Dogs who was liable because they had the power to tell how to operate the crane, and they were the ones who had hired the people. They had just lent it to somebody else to do their work, right? So in this case, Mercy Dogs were held liable. The next case which is up for discussion is what happens if there is a fraud which is committed by the servant and this fraud is during the course of employment. If the fraud is outside the course of employment, the master will definitely not be held liable. But what happens if in the course of the employment the servant commits a fraud? The case which is up for discussion is Lloyd versus Grace Smith and Company. Now this case is also a case in the principal and agent relationship. What happened in this case was Mrs. Lloyd was a widow and she owned two cottages. However, she was not satisfied with the income she was receiving from those two cottages and she consulted Grace Smith and Company, which was a firm of solicitors. Now this company sent their managing clerk to Mrs. Lloyd and he advised Mrs. Lloyd that she should sell off those two cottages. And for this said purposes, he made two sale deeds and got them signed. Now, these sale deeds were in fact gift deeds in favor of the managing clerk by Mrs. Lloyd. So then he disposed of the property for his own benefit. The matter, when it reached the House of Lords, it was unanimously held that Grace Smith and Company were liable for fraud of their agent or the servant, even though he was acting for his personal benefit and Grace Smith and Company had no knowledge of the fraud, yet the fraud was committed in the course of employment and it was during the authority which he had by the firm that he was committing that fraud. So during the course of the employment, he had committed the fraud. The essence here is that the one who authorizes somebody else to do an act is liable as he has done it himself. Even though Grace Smith and Company had not authorized the person to commit a fraud, yet they were answerable for any wrong which was done by their employee when he was working by the authority which was delegated by them. So here the authority delegated by them was to go and give consultation to Mrs. Lloyd. In this course, he committed a fraud. So it was assumed that he was acting in authority and he was held liable. That is, the company, the Grace Smith and Company, were held liable for the fraud of the employee. The next situation up for discussion is what happens in case of a theft by a servant. Can the master here be vicariously held liable? So the case is Morris versus C.W. Martin and Sons Limited. What happened in this case was that the defendants were given a fur coat for cleaning. Now, this was a cleaning company and they were given a fur coat for cleaning. They give this coat to the servant for the purposes of cleaning. Now, the servant, instead of cleaning the coat, stole it. The court held that the servant had stolen the coat while he was in the course of services, that is, in the course of employment. because the same had been entrusted to him for the purposes of cleaning, and hence the defendants, that is C.W. Martin and Sons, were held liable for the acts of the servant of theft. So, if in the course of employment the servant does any theft, the masters will be held liable. Lord Diplock here stated that the defendants cannot, in my view, escape liability for the conversion of the plaintiff's fur by their servant. They accepted the fur as bailee for reward in order to clean it. They put the servant as the agent in their place to clean the fur and to take charge of it while doing so. The manner in which he conducted himself in doing that work was to convert it. When he was doing this dishonestly, he was doing it in the scope or in the course of his employment in the technical sense, and hence the defendants, as his master, are responsible for his tortious act. So, any wrongful theft which is done by a servant while in the course of employment will also hold the masters vicariously liable. The next is, what happens if there is a negligence of the servant, and what is the liability of the masters in such cases? The case is Century Insurance versus Northern Ireland Road Transport Board. In this case, the defendant's servant was the driver of a petrol lorry, and while transferring petrol from the lorry to an underground tank, he struck a match to light a cigarette and then threw that matchstick on the floor where he was emptying the underground tank. Now, because of this, there was a fire and explosion which damaged the property of the owner of that property where the tank was there situated. So, what happened essentially was that the defendant's driver struck a match and threw it on the property where he was emptying his petrol tank, and the property of the person who owned that tank and property got damaged. In this case, the court held that though the driver lighted the cigarette for his own conduct, yet it was a negligent mode of conducting his work, that is, a wrongful way of doing an authorized act, and hence the defendants were held liable for the act of their driver because it was in the course of the employment of the driver. So here it was a wrongful way of doing an authorized act or a negligence on the part of the driver, yet it was during the course of the employment, and hence the owner, that owner of the lorry and the driver, were held vicariously liable. The next situation is, what happens if there is a mistake by a servant? That is, if the servant commits any mistake while in doing the work which is supposed to do. The case is Bailey versus Manchester, Sheffield and Lincolnshire Railway. In this case, one of the defendants' porter was responsible to ensure the comfort of their passengers and help them board right trains. The plaintiff was boarded in the correct train, but the porter mistakenly thought that he had boarded the wrong train and then violently pulled him out of the carriage, which resulted in certain injuries. In this case, the servant was acting under a mistaken belief that the passenger had boarded the wrong train, and also he had used the force to pull the passenger out of the train. The act of the servant was held to be in course of the employment, which he had no duty to do, but the defendants were still held liable for the same. The court held that a person who puts another in his place to do a class of acts in his absence necessarily leaves him to determine, according to the circumstances that arise, when an act of that class is to be done, and trusts him for the manner in which it is to be done. And consequently, he is held answerable for the wrongs of the person so entrusted, either in the manner of doing such an act or in the doing of such act under circumstances which it ought not to have been done, provided that what was done not by any mistake, that is under any caprice of the servant, but in the employment. Thus, it means that if something is done mistakenly while in the course of the employment of the servant, it will still be under the vicarious liability concept, and the master will be held liable, like in this case, the railway company was held liable. The next case is delegation of authority by the servant. The case is of Beard versus London General Omnibus Company Limited. In this case, what happened was that at the end of the journey, the driver stopped to have some dinner. Now, in his absence, the conductor drove the bus in order to turn it around and make it ready for the next journey. However, during this course, he negligently had an accident and the plaintiff was injured. It was held that the conductor was not authorized to drive the car, and since he was doing an act which was not authorized by him, he was outside the course of his employment, and it was held that hence the defendant company was not liable. Since the conductor was not permitted to drive the bus and he did that act, it did not come within his course of employment, and hence it was held that there was, since there was a non-delegation of authority here, without the permission of the master, the conductor did this act. Therefore, the conductor himself was liable and the master was not liable. These are certain specific instances where the master servant liability is being discussed, and it is clear from these that if the act is in the course of employment of the servant, that is, if it is related to his employment, or even if it is a wrongful way of doing an authorized act, the master will be held vicariously liable. We have understood that in case of vicarious liability, the master is liable for the wrongs of the servant. Now, what happens if this one servant injures some other servant in the course of employment with the same master? The doctrine of common employment comes into picture here. This is an exception to the rule that the master is liable for the torts committed by his servant during the course of employment. What this doctrine basically states is that the master will not be liable if a negligent harm is done by one servant who is acting in the course of employment, and this harm is done towards another servant. Now, this was established first in the case of Priestley versus Fowler. Here, the defendant's servant had injured another servant of the same defendant, who was the plaintiff in this case. So, the plaintiff was injured by the defendant's servant in his thigh due to breaking down of an overloaded carriage which was in charge to another servant. So there were two servants here. One was injured by the breaking of a carriage which was under the charge of another servant. Now the court held, since the wrongdoer and the person injured were servants of the same master, the doctrine of common employment was applicable and the master was not held liable. There are two essentials for the doctrine to apply, that is, the wrongdoer and the person injured must be fellow servants, and at the time of the accident they must be engaged in the common employment. Now, this doctrine was supposed to be based on an implied contract of service that the servants agreed to run risks naturally incidental to the employment, including risks on the part of his fellow employee. If the harm was caused by employer's own negligence, the employee could recover unless the employee's claim was defeated because of contributory negligence. Hence, it is the essence of this doctrine was that if one servant commits any wrong to other servant, the servant cannot recover damages. This case was Priestley versus Fowler. This was carried on for some time in England. However, with the passing of workmen laws and labour laws, this doctrine diluted. Similarly, in India, this doctrine is no longer applicable. The courts have discarded it, and also the Employee Compensation Acts and various other acts and insurance acts have set aside this doctrine, and the doctrine is no longer applicable both in India and in England. So it is only of historical importance. Having understood the concept of vicarious liability in case of master-servant relation, let's move on to a very similar and easier topic, that is principal agent relationship. Here, the liability, that is vicarious liability of a principal, is based on the maxim qui facit per alium facit per se. That is, one who does an act through another does it himself. So in this case, if a agent does any authorized act and if any tort is committed in this duration, the principal will be held liable. Now, the authority to do act may be either express or implied. The principal generally does not expressly ask the agent to do a wrongful act. But when the agent acts in the ordinary course of the performance of his duty as an agent, and if any wrongful act is done in this course, the principal becomes liable. Now, the first case is Lloyd versus Great Smith and Company, which we've already discussed, and the facts and the judgment are clear. And it is clear that for any wrongful act by the agent during the course of employment, which he has authority to do, then if a wrongful act is done, the principal will be liable. Let us look at the case of State Bank of India versus Shama Devi to understand another aspect of principal agent liability. In this case, the plaintiff's husband gave some amount and check to his friend, who was an employee in the defendant bank, for being deposited in the plaintiff's account. There was no proper receipt of deposit which was obtained, and the bank employee misappropriated the money. The Supreme Court held that the employee, when he committed the fraud, was not acting in the scope of bank's employment but in his private capacity as the depositor's friend, and hence the defendant bank could not be made liable for the same. So what is the sense here? That the work should be done as per the authority, that is, in the authority. Here, the amount and the check were not taken in the authority of an employee of the bank, rather in the capacity of a friend of the person. And hence, for such liabilities and for such misappropriations, the bank will not be held liable. Had the same person been sitting at the counter and his friend would have come and deposited the money, he would be held liable, because then he was authorized as an authorized person of the bank to collect money. Here, the money was not given as an authorized person of the bank but as a friend, and hence misappropriation. And thus, the bank was not held liable in such cases. So, with this, we have understood the concept of principal agent liability, which is very similar to the concept of master servant liability. With this, we come to the conclusion of our discussion on vicarious liability, having discussed the meaning, the Latin maxims, the master servant relationship, tests of how a person is a servant, what is the meaning of course of employment, various case laws and different circumstances. We've discussed the doctrine of common employment. We've also discussed the principal and agent relationship in case of vicarious liability. The essence of vicarious liability is that there is a liability on one person for the acts done by another when such person stands in certain relations with the other person. This can be either master servant relation or the principal agent relation, as we have discussed. For any queries, please mail me at shruti@mpdnlu.ac.in.